Welcome to another Cyber Collective podcast. My name is Elliot Cedar. I am the security consultant here at Pax8 APAC. Today we are joined by two very special guests. And as usual, we have an SME to talk about the topic at hand and our MSP partner. Anne Hoare is joining us from IT Agree. She is a specialised lawyer. I'll let her do an introduction in a moment around contract law and works closely with a lot of MSPs. Jai Dametto comes from Corp IT in Queensland, Technical Services Director and co-owner of Corp IT. I may have stuffed up your title a bit, so you can recorrect me, Jai, but he comes as our MSP lens to sort of keep us in check as part of this. Today's topic is around the Privacy Act reforms, and this is gaining a lot more traction because of the changes or the potential changes that are coming down the track. Overall, there's 116 odd Privacy Act items currently, going through legal status, going through basically reviews as part of the changes, because it has been quite some time since the Australian government has gone through changes around that. We are quite behind from a global perspective, so this is where we need to catch up. And I think a lot of it was driven obviously off the back of data concerns and cybersecurity concerns over the last few years, and particularly with some of the big things that's happened over the last 18 to 24 months. I think it's gained a lot more traction as well around Optus and Medibank and some of the other big ones around that as well. Of those 116, there are 38 that are currently being approved, and the remainder are approved in principle, which means there may be some modifications and things coming down the track. But a lot of these items do have the potential impact to change how Australian businesses work, particularly the SMBs, right? There are very specific items that are focused around that, and this is why we're here today. So without further ado, I will kick things off with a little bit more of an introduction. I'll start with Jai. Do you want to give an introduction about yourself, the business?
Yeah. Hi, I'm Jai Dametto. I'm from Corp IT. I am the solutions architect, but as we know, as an MSP owner, I'm everything. I do end-to-end, and I'll support anyone and do whatever I need to do to get the job done, like probably most of you listening. But my day-to-day is about ensuring the technical deliverable and our outcomes to our clients, right, which is core to everything we do. As we now are a MSSP, I guess, if you like that, or a TSP, focused on a security-based deliverable and outcome for every one of our clients. We just see that this is part of the core. So staying up to date with both Essential 8 and the Privacy Act are just part of what we do now.
Perfect. Thank you, Jai, and welcome. And our SME for today, Anne Hoare from IT Agree. Anne, welcome.
Hi, thanks, Elliot. Great to be here. Anne Hoare, the founder and CEO of IT Agree. Basically, we look after MSPs in terms of the agreements that you need with your customers. And, I really want to help MSPs because so many have trouble managing risk, concerned about risks. And, you get something like Privacy Act changes and, what is the MSP to do with that? So we work with MSPs all around the world, but, a good deal of MSPs in Australia. And I think it's interesting to look at things like the Privacy Act changes going on in Australia in the context of what's going on in the rest of the world as well. So, as I said, we're working with MSPs in North America and the UK and other parts of the world. And it's interesting to see how different countries approach, different areas. And obviously GDPR is like the gold standard, and various countries, look to the GDPR, but don't actually adopt it fully. So, it's interesting to see where those nuances are and, what's right for particular countries and what's needed in those countries for the economies and the consumers.
Thank you, Anne. And yeah, thank you. I think you touched on one of the points there around GDPR, and I've said to partners who are sort of just hearing about the Privacy Act reforms for the first time and trying to sort of understand it at a high level. I've said in the past that it appears to be very GDPR-like, right? It is our version of GDPR, very focused around compliance and basic data management, protecting PII. for the most part. And that leads down not just through enterprise, but all the way down to the SMB market as well. So thanks for raising that point. While we're with you, I guess we'll start with you and open it up. From your perspective, what is the primary driver around Australia looking at the reforms?
Yeah, so we've had the strength of a digital economy for many years now, but I think it's fair to say that the pace of change is accelerating. And really, when the Attorney General went out and did a huge amount of review work and consultation with the Australian public, found that people felt there wasn't enough protection or transparency around their personal information and what's happening with that. And, concerns when you're increasingly using different applications, working digitally, your whole world can be online, to a large degree. And, we're not seeing any slowdown in that. In fact, we're seeing an increase in that. We see, Copilot coming in and AI generally. That naturally people are going to be concerned what's happening. Yes, I want to use this and it's great and it's helping me with my life and with efficiency and so on and business gains and competitiveness. But what is happening with all this personal information? And should I be concerned about who I sign up with? What are they going to do with that personal information? So the driver really, the big label is the digital economy. But of course, behind that, the accelerating pace of change there.
Yeah, I think there's a lot of elements happening at the moment. There's, obviously the technical advancements which you talked about with the introduction of things like AI and Copilot, etc. There's a lot of political challenges that are changing, social challenges changing. I think a lot more people are sort of standing up and seeing that, right, what is happening with my data, right? What does my privacy look like? So those impacts of change are really sort of driving, at least in my mind, the driving force behind the reforms, right? The big security incidents that we've seen over the last 24 months as well, right? Standing up and saying, right, I don't want my medical information to be out there in the public. How is that going to be used? Can that be used to for malicious purposes, right? So those are the things driving it. We want obviously businesses, or the Australian government want to set guidelines around businesses and how they do business with the general public. Jai, from your mind, how does that impact you?
I actually think that it's great. It's actually the first time that I've heard customers raise their security concerns off the bat, right? Like AI. And the first thing that business owners came to an MSP for advice about it was the idea of, is my data secure if I use ChatGPT? My staff have started using it immediately. Should I be concerned? And we had a whole bunch of diluted information that was easy to consume so that our principals, our point of contacts could get across this and start communicating with their businesses effectively around policy, around control, around how to utilize that. But it was the first time we've actually had customers focus on that first rather than, hey, I've got new stuff to play with. It's really cool. And I think that is the growing maturity that we're seeing, right? It's not just the Privacy Act reforms that are and government that is in putting in policy. The education of our staff, our clients, our customers they're getting smarter, and they actually understand this. And it's really important then if they understand at least a little bit of it, that you're still the natural leader and you're staying on top of it and you can deliver the actual advice around it. So again, it's a lot of work to obviously stay up to date with this. And if you don't have the capability to do it, talk to Anne. But apart from that, the goal set should always be is that we do know more than what our customers are. This is our realm to be able to provide the technical advisor part of it. So again, I love it. I've actually really enjoyed it because rather than me trying to say, please, 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 our customers are saying, hey, what do I worry about with this? And I'm like, great place to start a conversation.
Yeah, definitely. I think you touched on a great point there that now's the time to be having these conversations because while there's 116 odd items in those reform packages, none of them have been entered into law just yet. So it's a great time to sort of get ahead. We know that there's at least 38 of them that have been approved and are ready to go. and might be able to shed some light in terms of timing, because I haven't seen that. But now's the time to have these conversations in preparation, rather than being on the back foot when they do get released, to sort of get ahead and start putting those technical controls in place, your processes, your policies, having those discussions with your clients to make sure that they're ready, as opposed to something like Copilot, which was dropped on us a little bit earlier than what everyone expected, and we also got to catch up, right, in a small amount of time to sort of keep up with demands and make sure our security is in check. And any additional thoughts on what Jai just mentioned?
Yeah, so a couple of things. I think, yes, there's 116 proposals, 13 agreed. We haven't yet seen the draft legislation. So whilst, you could take some general direction from what's in the 38 that have been agreed, and then, the next batch, if you like, will be the 68 agreed in principle. But I think the draft legislation is expected this year for the 38. Until we see that, we won't know, the nuts and bolts of how that's going, what's in the proposal is going to manifest into the law. And, there'll still then be a lot of consultation around that. But I think to your point, Jay, about, be the advisor with your customers, it's a double-edged sword in a way, because, yes, you want to take that lead role and know more than your customer around these sorts of areas. It's the customer that is typically the one collecting the data from those that are holding the personal information. And so, unlike with the GDPR, where we've got the distinction between controller and processor, the controller really being able to make the decisions about that collection process, and the processor, often the MSP in that situation, actually acting on those instructions and doing what's been asked in terms of backing up data and so on. So you've got to be careful as an MSP that, yes, it's your customer who's really the front facing to the collection of that personal information. And as the MSP, yes, hold that higher ground, but also don't inadvertently potentially take on more obligation around what is effectively the customer's obligation, So I think we're going to see with the reforms, as there's going to be greater onus on the customer in terms of collection, use, disclosure, retention. If you're the MSP providing a backup service, you have no idea what's in that data being backed up, the extent to which that includes personal information. What can you then impose on your customer to assist them to run to good practice, and also to show that you are doing your best to help them do the right thing?
Yeah, so I agree with that. I think from my perspective, once again, we need to get more involved with our clients, and it's an advisory role. It's not a dictatorship, right? The goal set should never be that I want to take the onus on my client's data. All of our contracts state that we do not. But do I want them to do better data management? 100%. We're now talking to our clients about things like Microsoft compliance and utilizing the 365 tool sets for data sensitivity labeling and data retention labeling. These are things that SMB have never had access to, but we're now getting to the point where they need it, and it's the right time to do it. They're included in most of their licensing, so why not implement a strategy around it? And then I don't need to know their data. They need to know their data, and I'm just giving them the right tools, the advice, and the capability to use it. And if we're going to mature as an industry of MSPs, we don't just keep the lights on now anymore, right? That's not my goal. Our goal set is to do more, and that's where we need to do more. That's where we can really provide value to them. And we're seeing a lot of success in that space. And that's before, obviously, the Privacy Act and the new Essential 8 recommendations and everything else that's coming through. What we're seeing now is that clients actually do want that. They're finding the need for it. And in a cloud-driven world where, especially everything has a cost, what we're figuring out is that they didn't care about what their data grew to when it was on site, and they had a pool, and that was fine until they needed to get a bigger pool. In the cloud, where it's all charged, they care. They now care about data retention. Great. Let's talk about data management. Let's get into it. And I'm finding those triggers to be really good intros into, can we do more with you? Can we help you better?
Yeah.
Not to take the responsibility, but to help. And I think that is a clear definition, right? Like you do need to be very clear with your clients on that.
Yeah.
Where
So
the risk lies.
alongside the cost driver, you can slip in the obviously the legal compliance driver as well, and assist with that. And it may be that MSPs get more involved in assisting with policy around data management, retention, in particular, because of course that's where we've seen a lot of the issues where organisations hold on to data for longer than they need to,
which is forever.
Which is yeah. I mean, how many people go through and do that data cleansing? But certainly organisations should not be holding on to that personal information for longer than they need to in terms of the purpose for which it was collected. Yeah, I think we might see, more in terms of policies that MSPs could usefully provide to their customers as tools to assist, and that sort of thing. But I think also in terms of the reforms, rather than just providing reasonable security around data protection, there is a move from data privacy towards data protection, and strengthening up those protections has come through in the proposals as to specifying what are the organisational and technical procedures that you're putting in place to assist with ensuring security of data protection. And I think that the privacy by design type approach, rather than that being an afterthought, it's leading. Where is our privacy position in the way that this is being set up, in the way that we are processing data, in the way that our processes and methodologies work.
Yeah, absolutely. Sound advice. I think it's no secret that a lot of partners struggle to have a security-based conversation, and particularly a risk-based conversation, as both you and Jai are referring to. And it's really just about understanding, what's coming and what's out there to sort of help drive those conversations, right? The more that you can lead as that thought leader, the trusted advisor, which is what everyone is looking to become, especially from the security side. Those are the type of things. And Jai, you mentioned something very early on that you may not be the specialist in all areas, but you know more than probably most of your clients know, right? And I think
so.
a lot of partners are in that very spot. I guess it comes down to a little bit of imposter syndrome, where you think, well, I'm not a Ann Hall, or I don't know everything to do with the Essential 8. It's like, well, you don't necessarily need to, but the fact is, you know more than your client is, and that's where they need support at the end of the day, because they don't have the time or resources to keep up with that. I want to just move to some of the specific items on the Privacy Act that could potentially impact SMBs and particularly MSPs. One of the things that has been it has been heavily focused on in the media is the potential impacts around the notifiable data breach scheme, which is one of the items. Basically, the removal of that exemption, that's SMB exemption, which is the $3 million benchmark before and a breach becomes reportable. As one of the items, I think it's one of the later ones in the approved in principle type items, but effectively that would have a big impact on a lot of SMBs, where if there is any breach with the removal of their exemption, you're now obligated to report that to the government, to the ACSC for the most part. Jai, I'll get your thoughts first. How do you see that impacting? I don't know how many clients you have within that sort of under $3 million range. Do you see that as a bit of a concern?
So the query that I have around this, and it hasn't been defined yet, is that as the MSP, if I am smaller than $3 million, am I required to report it? And I'm yet to see the definition, but this will obviously cement that, right? We are going to have to, even if our clients exceed it. From my perspective, we report it like 100%, right? And then the only issue you need to understand is the overheads that go along with that. So we recently had a security incident that, as far as I was concerned, met not notifiable breach requirement. Lodged all the notifiable breach, and the outcome for me was that our technical team was actually better equipped and ready to handle an incident like that than what they were, right? We were ready. We knew we had an incident response plan. We had the ability to be able to manage that. And the only reason it was notifiable breach was because there was a component which went out into a publicly visible market, right? It was contained before they even got involved. But as far as I'm concerned, we all need to be preparing for that idea of we have to notify breach. And I'll be clear, it's happening everywhere all the time. Some people, and including MSPs, just don't know that it's happening. And that's probably the most dangerous part, right? If we get better at actually identifying and notifying on these breaches, then as an industry, we can become better at it.
Mm-hmm.
Thoughts, Anne?
Yeah, I think it's one of the things that came through, isn't it? That, just because a business may have a turnover of less than 3 million, the public is still wanting to know what's gone on, not just a notifiable data breach regime, but beyond that in terms of compliance with the Act, what's happening with their personal information. But I think, like it sounds like you've implemented, Jay, a higher threshold than potentially what you're required to legally. I think that's a good way to go about things, is actually not to go for the lowest position that you're legally entitled to adopt and use, but to actually adopt a higher level. And you're only going to enhance the level of trust with your customers if you can display that and act upon that higher level of data protection that you implement in your own business as an MSP. In terms of trust, in terms of showing the way, and assisting your customers also to do that, to be, come back to the point of being more knowledgeable and more aware of the risks and your obligations, whether they be legal or how you feel you should operate as a good corporate citizen.
Yep, thank you, Anne. Jai, to kind of answer your question, and this is, again, because it's still going through modifications.
It hasn't been defined, yeah.
From a high level, I believe any business under $3 million would now be required to do that once that passes, right? So the short answer to yours is yes. Where that expands out from an MSP perspective, which is yet to be determined, is if you are that person supporting your clients, you need to report on their behalf, right? At the end of the day, I think the requirement will be the business itself. The directors of the company will be the ones responsible, right?
Yep.
As they are with insurance and running the business itself, they're ultimately the ones responsible to do the reporting. Whether there's a case for you being that MSP, that data security provider, or whatever the case may be, where you have certain liabilities, that's yet to be determined. But that point I just made.
I think the key thing that I think is that as MSPs, we need to be stating to our clients, hey, I recommend this is now a notifiable breach incident. We need to provide this, and we have to do the work for it, right? To provide the information on behalf of the client, because they don't have the capability to be able to deal with an incident like that. They're not even going to understand the nature of it or how it happened, right? That's the MSP's job. But I feel like now is the time to start saying, hi client, this meets this requirement. We want to instigate a notifiable breach on your behalf. And that's what we've been doing for the last year.
Yeah, and I think it comes down to really defining what a breach is, right? Having a account compromise is not necessarily a breach. It's whether they've touched the data, done anything with the data. That is kind of the definition where you look at the right of boom type concepts. So it's understanding that, and it has to be built into your policies to really reference what are those cases as part of your incident response plan, maybe through your insurance companies to say, all right, at what point do we then have to notify this to XYZ, right? In the case of Australia, it'd be the ACSC or the ASD, or cyber.gov.au would be the website to find that information from. Anne, are there any other items in those reforms that you're aware of that will heavily impact the SMBs and particularly MSPs in how they support their clients?
I think we've covered some of the key ones. I think automated decision making is going to be on the rise, and you know there's certainly risks around that, covered off specifically in the GDPR, where only certain types of decisions can be made solely in an automated fashion, and there are protections around that. If you were applying for a loan, for example, and the decision drivers are entirely automated, then that's potentially a risk area. And the rights around that, in terms of the individual's right to understand the process that has been utilised and to review that, and to have an alternative potentially for that automated decision making where there is in fact a human involved. So it's going to be interesting with the extension of that. Automated could just be rule based, but once we use AI, is the law going to recognise that involves a machine learning aspect and in effect a replacement for a human interaction in that decision? So I think as to the MSP's involvement in that whole area, I guess remains to be seen from a market perspective and obviously also from the legal perspective as to how any of that might be introduced. I think the controller processor side of things is going to be really interesting to see if Australia adopts any equivalent of that into the law there, because they're not just assisting, but there can be obviously a legal obligation around being a processor of that data. So some of those sorts of, I think, the emerging and new technologies and how the law is going to impact that, to the extent that's going to be taken into account in the law change, will be really interesting. Of course, we don't yet know what that's going to look like. But given the focus on the digital economy, very broad, big label, how much detail is that going to go into the law? We don't yet know.
Jai, any thoughts on that?
Yeah, I think start getting prepared. Like that's what I keep saying this, but I think at the moment we have seen this time and time again, but as our customers get smarter and they get to know more about it, right, we have to be at the forefront of it. It's our job and it's our goal set. They're not going to keep up to date with the technical deliverable. So when I was hearing Anne talk about that, I'm like, oh, okay, we're talking about data loss prevention, right? I know which toolset we have to be able to make an automated control to be able to do that. Oh, we need to control the life cycle. Okay, that's data retention, right? As MSPs, we need to know how to, like the problem that the business is facing, and then the technical deliverable and solution to be able to resolve it, right? And then provide advice around it. We don't have to implement it. We don't have to force people down this route. What we have to do is be ready to have a conversation with them so that they know how to get the outcome that they're chasing.
Yeah, in terms of being ready, I think it's, whatever you're doing as an MSP, to be thinking about the personal information impact of that, and the realm of what MSPs are doing seems to be extending, and the different types of agreements that we get asked for certainly would indicate that. But if you think, beyond some of the topics that we've talked about, biometrics, facial recognition and other biometrics, if you're involved in any way with that as an MSP, then, obviously there's a collection of personal information, and it's highly sensitive personal information. It's often the golden key around, around personal information, and obviously then a strong point for fraud to occur.
Yeah, there's a lot going on, and obviously with 116 odd items in that, we're not going to have the time to go through all of them today. There is another one that has come up in conversation quite a number of times for myself. obviously, there are some sort of very specific industry impacts around these reforms. Certain verticals are going to be heavily affected in terms of, how to manage data for the education systems or healthcare and things like that as well. So if you will sort of dabble in those verticals, those are things that you can start thinking about having a conversation with those specific clientele. The one that's much broader that I want to raise now is, and I can't remember which exact item this is, but there was language around the responsibilities and liabilities for directors of the business. Previously, the ownership came under the business itself, right? So the business would be the one that gets a fine if they don't. This is sort of jumping off the back of the notifiable data breach scheme. Is who is now liable? From what I understand, it's moved away from the business and it is going to the directors themselves, which means the directors of the business, the board members, can no longer hide underneath the business banner, right, and be removed from liability. The liability is shifting to be personal held by the directors and the boards of the business themselves, which means their own personal livelihood is at stake. So one of the impacts of there that we've seen so far is making poor business decisions, particularly around data privacy and security, where they just go, look, if something happens, the business is affected, I can wear that, or the cost of the business, the fines can be sort of put under the cost of the business itself or through the insurance. So with that change, obviously with directors being potentially being personally liable for any bad decisions or a particular breach out there, that is something that's going to be a big driver in terms of making sure business are on board and have at least baseline security practices. And how do you see that sort of taking shape?
Yeah, I think, it's interesting to see that coming specifically into legislation such as the Privacy Act, because generally, you've got, as a director, obligations to the company under company's law anyway. But, you're seeing here, as you've mentioned, specific examples where directors can be made liable specifically.
Jai, have you had conversations around that today?
I think it's the government acknowledging that the fines don't work against companies, right? Like they're just saying outright, like we've got these, powers and capabilities and make massive fines against people like Medibank and the other people that had breaches last year. They just go, yeah, okay, that's the cost of doing business, or it's an insurable position, and they move away from it. They don't fix their practices. This goal set is obviously saying, well, that's not working. How do we get the business leaders within these places to actually change the way they approach this? It can't be ignored. It can't be like this idea of like, oh, it's just the IT guy's problem. Let's put it over there and don't worry about it. We're not going to take their recommendation. Like it's actually something that now we're saying, no, it's important. You need to stand up and listen. It's actually could affect your livelihood, right? I think it's a good thing. As a business owner, of course, I take that very seriously because that's my livelihood. On like when if it ever came into having a defensible position against a client, saying no, that was your responsibility, right? Well, no, we provided recommendation and advice. This is where we got to. You didn't want to accept it. This is where we got, this is the acceptable position of where we disagreed on, what you would actually take up as practice. I don't enforce anything on anyone, but I think it's really important that we're providing that advice and that conversation. And likewise, whether it's internal IT, an MSP, a technical advisor, or anything else, like that is the goal set, right? Put something in place and try and recommend the changes for the businesses to grow. This can only help, right? It can only help the business leaders, the owners start to take directors, any board members, they literally won't listen to anything. You start saying they're actually responsible for it. Okay, maybe they'll start listening.
Yeah. Again,
Yeah,
we need to see what actually is presented in that draft legislation to work from there.
Of course. Yep. It's all subject to change, right? So this is early discussions to hopefully start driving the message across. And I think, it's not going to be done without sort of community involvement for some part, right? There are certain bodies that are sort of guiding the process and having a say. And obviously the SMB community is going to be a big part of that because they're going to be affected as much as the enterprise. And there's 90 odd % of businesses are SMBs, so they should have a bit of a say in that, and that includes coming from the likes of the MSP community as well. One of the things, and this will probably be the last question before we sort of start closing things off. One of the last things has been raised around potential liabilities for the MSP itself around these potential Privacy Act reforms that are coming through. One of the examples that have come up in conversation is there seems to be some grey areas there. There is language to sort of call out that if you touch the data or have the potential to touch the data, which, Jai, you can correct me if I'm wrong, as an MSP, you probably hold God rights to all your clients' data, right, being managed in the Microsoft environments, etc., that you potentially could be liable for any sort of breach as well. And is there any sort of clarification around that in your experience, or any sort of wording that you can sort of suggest whether that would be the case, and any other liabilities that MSPs may need to consider?
Yeah, well, again, are you collecting the data, and how is that currently captured in the Privacy Act, but in the revised law, it's going to be interesting to see whether they adopt something like there's a definition of processing in the GDPR, which is quite extensive. If you are able to touch the data, that's making the definition very, very broad. So, I don't really have much more of a comment until we see what actually comes into the draft legislation, but that would be obviously immensely concerning for MSPs if that was the case.
Yeah, fair. Jai, would that be a big impact on your business?
Start now. Get your contracts in order. Make sure it states that it's not part of your service offering. Limit your access. Use things like privileged identity management, delegated, like granular delegated admin privileges. Start limiting your risk factors involved with your client's data and business, right? Start creating a cycle where there's access reviews. Like, we have all these tool sets and capability, and I'm referring to some of them. But the goal set is that probably don't hold God mode and admin to every one of your clients with every one of your staff members every day of the week. Like, limiting that surface area is massive. And like I said, like it doesn't. I don't need legislation to tell me that you do the right thing, right? Let's just start doing the right thing. Let's start now. Let's get prepared. An MSP, from my perspective, again, like, rely on your contracts to say, no, I do not touch your data, nor do I understand it, nor do I manage it. I manage the data stores, so we're very clear on the definitions of how we do that. I manage your backups. I still don't access your data. I still don't touch your data. I present you with your data to do a recovery, right? Like, be very clear on the definitions on what you are and are not allowed to do, and then obviously audit everything. If somebody breaks those rule sets or those policies or those guidelines, you need to have ramifications against that, right?
Absolutely, yeah.
Yeah, definitely. I'd encourage all MSPs and, even speak to your clients who have concerns potentially around some of these things that are coming out to, engage with your local senators or your local governing parties, whoever that may be, to help guide this process through, right? To make sure that they don't push things out without proper community collaboration. One of the things that they did say is that this is not going to be something that they implemented in law and happens overnight. They will provide a bit of lead time into it to make sure everyone's doing the right thing, so that no one's impacted as part of that too quickly, right? So it's not shoved down our throats and have to sort of rush to get things up into play. And we've talked about a lot about the reforms, but with your knowledge today, what are the things in the Privacy Acts that MSP should be thinking about now until those reforms come into play?
Sure. So firstly, have a look at what's in your contracts right now around personal data protection, and to think about the personal information impacts of the services that you're providing. So, number one, MSPs are collecting personal information in terms of their customers' staff details. So that's personal information right there. But what other sorts of services are you providing in which you may be collecting personal information from your customers? And in turn, on what basis are those customers collecting the personal information from the individuals concerned or from other sources? So, yes, it's certainly, from my perspective, looking at contracts, what is in your contract around these sorts of areas is a really good place to have a look. But not only that, it's operational as well. So you could have the best contract in the world around these sorts of areas and others, but if it's not how you're operating, it's not going to provide the same level of protection as what you might be expecting. So don't have your contract set up, put it away and forget it. It needs to be actually, this is how you're operating. It doesn't mean to say that all of your staff need to study the contract. It needs to be in the DNA of how you operate. And, there's various ways of, training your staff as to, the processes that you agree with your customers will be in place and making sure that happens, So I've seen that so often where immense amounts of work will go into a contract and it's totally separate from how the business is operating in terms of projects, support services, and scope out of scope. But, here we're talking about protection of personal information, and obviously that's a key area where MSPs need to be very clear with their customers about what they're committing to and what they're expecting from their customers.
Great. Thank you. Jai, any thoughts on what do you guys do around the Privacy Act?
Contracts. Completely agree. 100% contracts. It'll always come down to that, because if you're going to get hung or held responsible against it, that's where it's going to come back to. So if your contracts aren't in place and they're not up to date, they're not binding, they're not re-signed, I don't know, whatever, if you're not recontracting your clients, it's really important that you can lean on a document that states, no, these are the delineations of responsibility, right? We don't take on that responsibility. So we have historically, I can be open about this, historically at Corp IT had some problems with this. We have made a concerted effort to do both of those objectives, and talking about one is recontract and make sure that everything's viable and actually applicable. Second part, start teaching our staff what is, part of our service offering and what's not, right? And be very clear about that as well. It's a great conversation, and once you get through it, it makes life easier. It's hard. It's hard to get through it, but it's a great conversation to make sure you get through.
Absolutely, great advice. All right, we'll start to go into our final thoughts. Any final comments, advice for the partner base? Jai, we'll start with you.
Yeah, I think with all of this, this is all just maturity, right? Growing from being a lights on MSP into something a little bit more mature. And for me, again, whether it's legislative or not, we can all do better in this space. We can all make advances in this space. Find your people that are passionate about it, right? Someone that's someone that's really going to drive it in your business, and then give them the authority to do it, right? Make sure that they understand that data management is something we're going to be doing as part of an advisory service for our clients. And then probably lastly, don't try and do it for free. Don't give it to your customers. Some of this is very difficult. Some of it's extremely complex, right? Don't just say, hey, clients, we now give this to you as a certain, these things are extremely high level resourced, high impact, high control, needs a lot of time. So, think about how you price and deliver those kind of guidelines so you've got a viable business moving forward as an MSP.
Great, thank you. And your final thoughts?
Yeah, so adopt processes that truly reflect your data management processes, particularly in terms of personal information, and ensure that they're at least in compliance with the law, and then reflect those to the extent they need to be in your contract. Not everything needs to be in your contract, but the right things need to be in your contract so that you're agreeing with your customer the basis on which you're going to work with them, and the expectations that you have of your customer.
Fantastic advice. I'm sure a lot of our partners will probably need help with that. So, Anne Hoare is from IT Agree. She's got a bit of a team behind her that helps supports. If you are MSP looking for support around contracts in particular, please reach out. It's itagree.com, Anne. Is that correct?
Yes, that's right. Yes.
Perfect. Give you a bit of a plug there. We do obviously recommend IT Agree to a lot of our partner base. So please do reach out if you have any questions or need any support around your contracts. Thank you both for joining today's session. I think it was a very enlightening conversation, particularly for me myself. I've learned a couple of things just talking to you, both of you, in terms of the MSP perspective, in terms of your legal expertise, and I think a lot of our partners and the MSP community in general will get a lot out of this. So really, really appreciate you both being on, and thank you for today.
Thanks,
Yes.
Elliot.